I acknowledge the original custodians on the land of which this campus stands and pay my respects to their elders past, present and emerging, and acknowledge the unique role they have played in the life of this region. I'm very honoured to be asked to present the annual Michael Kirby Lecture this year, particularly with the Honourable Michael Kirby present. Reflecting on my topic, reimagining native title through the eyes of Justice Kirby, it did struck me last night actually how courageous or perhaps foolish it is for me to attempt this topic in his presence. But I've never been lacking courage in these matters, and it feels a bit like hang gliding at the moment. Once you're standing on the edge of the cliff and you're strapped in, it's too late to change your mind. It's fitting to be talking about native title this year, the 25th anniversary of the decision in Mabo. I intend to take you on a journey of native title, seen through the eyes of Justice Kirby, exploring how His Honour influenced, and as the case often was, dissented to the direction in which the doctrine of native title developed in his 13 years of service on the bench of the High Court of Australia. I'll outline where the law of native title had landed in 2009 when Justice Kirby left the bench, far from the native title His Honour had imagined in his judgments. Finally, I'll briefly review recent developments in native title law through 3 High Court cases which have moved the picture of native title closer to that envisaged by Justice Kirby. So, to step off the cliff, let's start 25 years ago with Mabo, when the High Court found the Meriam people are entitled as against the whole world to possession, occupation, use and enjoyment of the lands of the Murray Islands. And with those words, the High Court inserted the legal doctrine of native title into Australian law. This was a truly watershed moment in Australian legal history, though it was not, of course, without critique and debate. The in-principle recognition of native title underlying Australia's established systems of property law led to criticism that the High Court had usurped the legislative function and excited ambition, consternation and vituperation from those who thought their interests may fall within the scope of the emerging Mabo principle. As Justice Kirby observed extrajudicially, rarely has a decision of an Australian court attracted so much praise and so much calumny. Writing in 1994 in defence of Mabo, Justice Kirby, then President of the New South Wales Court of Appeal, commended the decision for its legal significance and reasoning. Firstly, His Honour emphasised with approval that the court had recognised the legitimate claims of Indigenous people to native title, overruling the inappropriate application of the common law doctrine of terra nullius to the Australian continent. Indeed, he stated, "No fair-minded person with knowledge of the Aboriginal presence in Australia before British settlement could seriously object to the decision of the nation's highest court in refusing any longer to build its laws as to land title on a myth and a falsehood." Justice Kirby also applauded that the court provided valuable guidance to an Australian court in respect of the proper circumstances in which long-standing rules of the common law in Australia may be overruled, and the proper influence which international law and international instruments may play in the development of the common law. Finally, His Honour acclaimed the decision and the surrounding debate for bringing to the fore the important issue of the judicial role in a constitutional democracy. And in Justice Kirby's view, the criticisms of the court in Mabo usurping a legislative function overlooked the legitimate judicial function of judicial creativity in the law. Ultimately, His Honour observed that the decision was consistent with the duty of the courts to attain a proper balance between stability and adaptation of the common law to new and ever-changing social circumstances. He stated, "Mabo will be viewed as an illustration of the way in which the common law system eventually corrects itself of most errors and rights most wrongs. Being a system based upon human reason and justice, it eventually attains those goals. Far from being a revolutionary usurpation by the judges of legislative power, Mabo is an example of common law in action. Mabo provided a framework, a judicial stimulus to action for the recognition of Indigenous title, but it left many questions unanswered. Justice Kirby called for the framework to be completed by subsequent case law or legislative enactment. The Native Title Act was enacted in 1993 as the statutory response to Mabo, and by the time many of those unresolved legal questions reached the High Court, Justice Kirby occupied a seat on its bench. From 1996 to 2002, Justice Kirby sat on 8 significant native title decisions involving native title. In 2008, the year before he left the bench, he sat on 2 other cases which gave him further opportunity to comment on native title. One of the first and most prominent issues to be resolved after Mabo was the relationship between native title and pastoral leases. The answer to this question would in large part determine the scope for native title on mainland Australia. On the 7th of February 1996, just one day after Justice Kirby was sworn as a Justice of the High Court, the Court heard argument on the pastoral lease question in North Ganalunja, Aboriginal Corporation and Wanyee peoples and Queensland. The matter was triggered by a decision of the then President of the National Native Title Tribunal, Justice French, that an application for a determination of native title over land subject to a pastoral lease not be accepted for registration, because the effect of the grant of a pastoral lease under the Queensland Lands Act was to extinguish native title. An appeal to the full Federal Court was dismissed. The High Court, on appeal, declined to consider the substantive pastoral lease issue, emphasising instead the beneficial character of the procedures established by the Native Title Act, which once invoked must be observed. The Court was short in upholding the appeal. So keen was the High Court to set aside the full court decision that it did so immediately, with reasons to follow, adjourning for only 7 minutes following 2 days of argument with 20 counsel appearing before the court. Deciding for the Wanyee people on the procedural question and determining that it was premature to consider the pastoral lease question, the court directed that the application for determination of native title be accepted, triggering the valuable negotiation and procedural rights of the Wanyee people contemplated by the Native Title Act. But in contrast to the majority, Justice Kirby was of the view that the court should have determined the pastoral lease question, stating with somewhat dramatic flair, until determined it will remain a Damoclean sword hanging over the operation of the Act and the rights of many parties, including those presently before the court. And certainly it was not long before the issue came before the court again, with pretty much the same counsel, perhaps a few more, heading off again to Canberra just a few months later to argue the pastoral lease question a second time in Wik Peoples and Queensland. Wik was decided by a bare majority of 4-3, and Justice Kirby's opinion in favour of the Aboriginal appellants was decisive in the outcome, determining the Queensland pastoral leases under consideration did not confer rights of exclusive possession and therefore did not necessarily extinguish native title. The decision was significant, as it meant that native title could coexist with other interests. However, it also reinforced the superiority of granted rights over native title rights. The test is inconsistency, where there is no inconsistency between the rights granted under the lease and the rights conferred by native title, and therefore no necessary extinguishment, native title will survive and coexist with the rights under the lease. However, if inconsistency is found between the rights conferred by the grant of the pastoral lease and the native title rights, the rights under the pastoral lease will prevail. Now, Wik can be considered as important as Mabo for shaping the future of native title. It opened up the possibility of native title existing over vast swathes of Australia, where it was previously thought to have been extinguished, including by 3 other justices of the High Court, 2 members of the full Federal Court in the Wanyi case, Justice French, and many leading lawyers and academics. In his Honour's extrajudicial writings, Justice Kirby noted the unrelenting attacks by politicians and others to which the court was subject in the wake of the Wick decision. The response to the decision, he said, constituted some evidence of a decline of civic understandings between the branches of government in the Australian Commonwealth, observing that it was a very sorry episode in the relationship between the Parliament and the court. Justice Kirby noted that following, and as a direct result of Wick, there was a commitment by a leading government politician that capital C Conservatives would be appointed to replace retiring justices, and that the philosophical balance of the High Court indeed shifted significantly after his own appointment. The next case was Fiju and the Northern Territory in 1998. The Larrakia people, whose country included areas around Darwin in the Northern Territory, sought a declaration of native title in the Federal Court. The case concerned an area of land which was once granted in fee simple, but had later reverted to vacant Crown land. On appeal, the High Court considered whether native title could still exist over land which was once granted in fee simple, but later reverted to Crown land. The High Court held that native title was extinguished by the freehold grants and that the extinguishment was permanent. It cannot be revived when the land is once again held by the Crown. Writing in a separate judgment, Justice Kirby agreed that the freehold title conferred by the Northern Territory could not coexist with native title and emphasised the inconsistency lies not in the facts or in the way the land is used. It lies in a comparison between the inherently fragile native title right, susceptible to extinguishment or defeasance, and the legal right which fee simple confers. In relation to the appellant's contentions that the extinguishment might be retrievable, Justice Kirby expressed sympathy and stated the extractions of embracing a principle of revival of native title are strong. Indeed, His Honour hypothesised a rule of the common law could doubtless be formulated which permitted the lifting of extinguishment for a case such as the present. Such a rule might leave private owners of land in fee simple fully protected, but exposed to such claims governmental land holdings of the very kinds of land in which native title might have found its most practical meaning. Despite this, Justice Kirby found, for reasons of legal authority, principle and policy, he could not accept the proposition that extinguishment occasioned by the grant of fee simple is other than irreversible. His Honour posited the true test propounded by this court involves a comparison between the legal character of the interest in land under Australian law and the native title interest in the same land. By that test, there is always inconsistency where the interest in question under Australian law is one of fee simple. So fragile is native title, and so susceptible is it to extinguishment, that the grant of such an interest without more blows away the native title forever. Extinguishment was revisited in Yannaraneten in 1999, where the majority, including Justice Kirby, held that although the Queensland Fauna Conservation Act regulated the way the native title holders' rights and interests to hunt and fish for crocodiles may have been exercised, it did not extinguish those rights. The court's reasoning was centred on the concept of native title as recognised by the common law. The joint judgment put forward an understanding which would prove, in contrast to future decisions, that Aboriginal ownership is primarily a spiritual affair rather than a bundle of rights. The judgment went on to state an important aspect of the socially constituted fact of native title rights and interests that is recognised by the common law is the spiritual, cultural and social connection with the land. 2 years later, connection with the sea was the focus of Commonwealth and Yamea. The High Court held that native title could exist in the sea and seabed, though the rights and interests were not exclusive. The court considered that the question of whether the common law will recognise native title over the seas is essentially an investigation as to whether and how the common law and the relevant native title rights could coexist. The majority held there was no necessary inconsistency between the Crown's assertion of sovereignty over the territorial sea and the continued recognition of native title, but rejected the claimant's assertion of exclusive rights for two main reasons. Firstly, they took into account and upheld the trial judge's evidence, the finding of evidence indicating that the requirement to seek permission to enter the claimant's country only applied between Aboriginal people. Secondly, the majority held that there was a fundamental inconsistency between the asserted native title rights and interests and the common law public rights of navigation and fishing, as well as the right of innocent passage. The two sets of rights cannot stand together, and it is not sufficient to attempt to reconcile them by providing that exercise of the native title rights and interests is to be subject to other public and international rights. Justice Kirby, writing in a strong dissent, was critical of both aspects of the majority reasoning for taking an overly narrow approach. A broader approach to determining exclusivity was appropriate, he said, noting that from the perspective of the claimants, rights could retain a characteristic of exclusivity while being qualified by other public rights in the same area. Nor did he see any reason of principle or policy why a grant of a non-exclusive fishing licence is inconsistent with a residue of exclusive elements of native title in the sea. And Justice Kirby was also deeply critical of the reliance on the fact that the claimants had not enforced their rights against non-Aboriginal parties as a basis for finding that those rights were not exclusive in nature. He said, "It would not be reasonable for a court to place undue weight on methods of enforcement of Aboriginal rights against non-Aboriginal persons. How, it might be asked, were the forebears of the claimants expected to assert and uphold their rights to their sea country when the Ballender enjoyed indisputable superiority of weapons and, until Mabo, incontestable superiority of legal rights?" His Honour would have found in favour of the claimants that qualified exclusive native title rights in the sea could be recognised by the common law, explaining, "They yield their rights in their sea country to rights to navigation in and through the area, allowed under international and Australian law, and to licensed fishing, allowed under statute, but otherwise they assert a present right under their own laws and customs, now protected by the white man's law, to insist on effective consultation and a power of veto over other fishing, tourism, resource exploitation and like activities within their sea country because it is theirs and now protected by Australian law." The next year, in 2002, Western Australia and Ward gave the High Court the opportunity to clarify the concept of extinguishment after a rather disparate collection of concepts and judicial terminology had developed in native title cases to that point. It held that pastoral leases and mining leases did not necessarily extinguish native title in Western Australia, though it was the reasoning that led to those conclusions that was particularly important. Over 10 years since Mabo, two principles for common law extinguishment had emerged: a presumption of no extinguishment without a clear and plain intention, and a doctrine of inconsistency between two sets of rights. By giving primary regard to the Native Title Act over Mabo and Wick, the majority held that the mandated test was that of inconsistency. But the court also characterised native title as a bundle of rights, which could be extinguished in part or incrementally. And a significant aspect of the majority reasoning on partial extinguishment was the move away from a more holistic approach to the underlying concept of native title as an expression of communal responsibility and ownership. The effect of the Ward decision on native title was profound. It confirmed prior grants and interests could extinguish native title in part, in effect permanently extracting particular rights and interests from the native title bundle and leaving a patchwork of extinguishment across Australia. Justice Kirby concurred generally with the joint reasons of the majority and their general approach to construing the Native Title Act and state and territory legislation. However, he recorded some significant reservations in relation to the concepts of recognition and extinguishment. He noted these concepts, as outlined in the Native Title Act, are ambiguous or informed by the common law. He identified three interpretive principles the court should apply in giving them meaning. First, in the case of ambiguity, the interpretation that upholds fundamental human rights rather than one that denies those rights should be preferred. Secondly, so far as is possible, it should take into account relevant analogous developments of the common law in other societies facing similar legal problems. Thirdly, a clear and plain purpose is required for a statute to extinguish property rights, particularly where the legislation purports to do so without compensation. In Justice Kirby's view, the provisions should be construed consistently with the principles of fundamental human rights, as expressed in international law, stating there is no aspect of those principles that is clearer or more emphatic than that which forbids adverse discrimination for reasons of race. Also of relevance is the international law that protects the interests of Indigenous peoples, who are often specially vulnerable to racial and other forms of discrimination. The Native Title Act itself contemplates that this should be so. Justice Kirby noted that the concept of recognition, which began with Mabo and is now governed by the Native Title Act, does not affect underlying Aboriginal law. His Honour understood that system of law operates separately, regardless of any recognition or extinguishment by the Act or any other legislative regime. He also proposed a more holistic understanding of native title rights and interests than the bundle of rights posited in the majority reasons, emphasising that the object of the Native Title Act is the recognition of native title, rather than the provision of a list of activities permitted on or in relation to areas of land or waters the subject of the claim. His Honour illustrated the divergence in his approach to recognition from that in the joint reasons by reference to two contested aspects of the claimed rights: the use of resources and the right to maintain and protect cultural knowledge. The asserted right, native title right to use resources was illustrative of the ease with which a narrow interpretation of Section 223 of the Native Title Act, that is the statutory definition of native title, would restrict its beneficial operation to accord full recognition to the interests and aspirations of native title holders. While His Honour agreed that in the matter of Ward, native title to minerals and petroleum had been extinguished by legislation, His Honour's view was that a right to resources should be conceived of broadly to the possible inclusion of minerals and petroleum where they exist, rather than requiring specific proof of the historical use of identified resources. Significantly, Justice Kirby asserted the possibility of the development of modern aspects of traditional rights and interests. In His Honour's opinion, it would be a mistake to ignore the possibility of new aspects of traditional rights and interests developing as part of Aboriginal customs not envisaged or even imagined in the times preceding settlement. He envisaged an approach that took into account the pressures that existed in relation to Aboriginal laws and customs to adjust and change after British sovereignty was asserted over Australia, and allowed the extension of historical traditional uses of resources to modern conditions. The principle of equality of the rights of all Australians before the law was fundamental in His Honour's reasoning. The High Court was also asked by the Aboriginal appellants to reinstate the finding at first instance of a native title right to maintain, protect and prevent the misuse of cultural knowledge associated with the claim area. And the majority held that such a right is not susceptible to recognition under the Native Title Act. Justice Kirby disagreed. For a native title right to be recognised, the critical threshold question is whether the right or interest is in relation to land or waters. The phrase "in relation to" is very broad. At the time of Ward, the words had not yet been the subject of much elucidation in native title decisions, as the native title rights claimed had so far related physically to land or waters in a manner analogous to common law property concepts. The claimed right to protect cultural knowledge in Ward provided the opportunity to elaborate the well-established principle that native title is sui generis and should not be restricted to rights with precise common law equivalents. Noting the extreme ends of the spectrum of the right, which could, at one end, be to restrict access to a physical area of land and waters, at the other, to restrict access to representations, images or oral accounts relating to land or waters. Justice Kirby emphasised the inherently spiritual connection between Aboriginal Australians and country, and the inextricable link between cultural knowledge belonging to Aboriginal people and their land and waters. In His Honour's view, if cultural knowledge is inherently related to the land according to Aboriginal beliefs, it follows logically that the right to protect such knowledge is related to the land for the purposes of the Native Title Act. This construction, he said, was consistent with the purposes of the Native Title Act, evinced in the preamble, including the full recognition of the rich culture of Aboriginal peoples and the acceptance of the unique character of native title rights. His Honour also considered it supported by Australia's ratification of international instruments providing for the protection of fundamental human rights. Finally, His Honour raised a possible constitutional argument for the protection of the right to cultural knowledge through the application of Section 116 of the Constitution, which provides a prohibition on laws affecting the free exercise of religion. Turning to extinguishment, Justice Kirby agreed with the joint reasons that a previous Exclusive Possession Act will extinguish native title, and that the relationship of all other interests with the asserted native title raises the question of inconsistency. However, His Honour found the reasonable user test useful, providing examples of pastoral leases which usually confer rights and interests to make improvements necessary for pastoral activities and prevent others from engaging in pastoral activities on the same land, and are not necessarily inconsistent with native title rights. He reasoned the terms of mining leases similarly usually confer exclusive possession only to the extent necessary to prevent others from carrying out mining. Justice Kirby recalled his dissenting opinion in Yamir in relation to inconsistency and exclusivity, that is, that native title rights could retain a characteristic of exclusivity while being qualified by other rights in the same area. While he noted his view was a minority opinion and he was bound to accept the categorisation of exclusivity in the majority approach in Yamir, His Honour again outlined his preferred interpretation in the context of the circumstance in Ward. That is, Justice Kirby favoured the recognition and non-extinguishment of the claimed right to speak for country as a form of exclusive title, including the rights to determine the uses of the country concerned, protect that country from degradation and care for it spiritually. He opined the grant of non-exclusive mining leases or reserving lands were not sufficient to extinguish otherwise exclusive elements of native title, including the right to speak for country. Justice Kirby acknowledged that until his dissenting view finds favour in a majority in the High Court or is legislated, he must, and did, submit to the law as expressed in the majority opinion. Wilson and Anderson was handed down the same day as Ward. It raised the question of whether leases for grazing purposes in the Western Lands Division in New South Wales extinguished all or any native title. The High Court had already found that native title could coexist with Queensland and Western Australian pastoral leases in Wick and Ward respectively. The majority in Wilson and Anderson held that the New South Wales leases granted in perpetuity for the purpose of grazing extinguished native title entirely. The rationale behind the paradoxical perpetual lease was to strengthen the class of tenure to ensure that lessees could obtain adequate finance on the security of their lease. By aligning the perpetual lease with freehold in the sense of permanency and ignoring its limitations in respect of use, the majority in the High Court made a presumption of inconsistency in line with freehold. Justice Kirby, again in a strong dissent, concluded that the New South Wales leases did not confer exclusive possession and therefore did not lead to complete extinguishment of native title. And there is perhaps no more illustrative picture of native title seen through the eyes of Justice Kirby than his description in Wilson and Anderson of being in the jungle of native title legislation. Under this subheading, His Honour wrote, "That impenetrable jungle of land legislation remains, but now it is overgrown by even denser foliage in the form of the Native Title Act and companion state legislation. It would be easy for the judicial explorer to become confused and lost in the undergrowth to which rays of light rarely penetrate. Discovering the path through this jungle requires navigational skills of a high order. The only way to pass through the jungle is to retain one's bearings, as explorers of Australia have traditionally done, by keeping the eyes fixed on clear sources of light, like the rising sun in the morning, or at night the constellation we call the Southern Cross. That is what I will try to do in these reasons." One beam of light in the legal jungle, identified by Justice Kirby, was the fundamental principle that native title rights and interests should persist in the face of legislation said to be inconsistent with them, unless there is a clear and plain intention to extinguish such rights. His Honour cautioned the court to be slow to reverse the steps taken by Mabo and Wick in the recognition of the native title rights of Aboriginal people, noting that there were already enough legal and practical impediments to the attainment of legal protection for native title rights without eroding the principles accepted by the majority in those two cases. But even more impediments were put in place shortly after by the decision in Yorta Yorta and Victoria. Yorta Yorta was concerned with whether native title was extinguished by non-acknowledgement and non-observance of traditional customs. The majority of the High Court held acknowledgement and observance of the normative rules of a society must have continued substantially uninterrupted since acquisition of sovereignty. Yorta Yorta brought this concept of continuity of a traditional society to the forefront in its consideration of native title in the southeast corner of Australia, where Indigenous people had experienced 7 or 8 generations of intensive non-Indigenous presence and activity. The finding of the trial judge that native title had been washed away by the tide of history was confirmed. Justice Kirby, however, writing in a joint dissenting judgment with Justice Gaudron, considered that the definition of native title in the Native Title Act did not require continuity of traditional community as a prerequisite for a determination that native title exists. Their honours concluded that the relevant issue was simply whether the Yorta Yorta people now acknowledge and observe traditional laws and customs by which they have a connection with the land and waters claimed by them. The implications of the Yorta Yorta decision were profound for many native title claims, particularly in settled areas. In the wake of Ward, Wilson and Anderson and Yorta Yorta, Maureen Tehan reflected on native title in Australia. She wrote, 10 years of the Native Title Act has seen the common law of native title emerge, blossom, change and wilt. The promise engendered by Mabo has failed to materialise in the form of a robust and enforceable native title. To that extent, the sun may have set, with native title fatally wounded by the Native Title Act and the High Court. Reflecting in 2005, after nearly 10 years on the High Court, Justice Kirby noted the number of native title cases that were coming before the court at the start of the decade had begun to fall away. He mused that this may have been in part because of the 1998 amendments to the Native Title Act, in part because the basic principles passed post-Mabo had been settled and Indigenous communities now preferred to negotiate settlements rather than to litigate, and in part because of a diminished belief in good outcomes in the courts. There were 2 more opportunities for Justice Kirby to comment on native title in cases coming before the court in 2008. Griffiths and the Minister for Lands, Planning and Environment was concerned with the compulsory acquisition of native title in Timber Creek, a small town roughly halfway between Katherine in the Northern Territory and Kununurra in Western Australia. The acquisition was for the purpose of granting a number of Crown leases, one in particular being to graze goats. At issue was the power of the Northern Territory government to compulsorily acquire the land subject to native title, both when there were coexisting non-native title interests in the land and when there were not. The majority held it could, as long as the acquisition was not discriminatory. The majority also held the power conferred on the Minister by the Northern Territory Lands Acquisition to acquire land for any purpose whatsoever extended to acquisitions for the purpose of subsequent sale and private lease. But I hear that the goat grazing licence was never granted because by then the applicant had given up. Justice Kirby wrote in strong dissent. His Honour concluded there was an absence of express and unambiguous provisions in the Land Acquisition Act to uphold the unusual kind of acquisition of native title interests, and the Northern Territory's notices of proposed compulsory acquisition were therefore invalid. The majority's reasons could be persuasively explained if a purely literal approach was taken to the interpretation of the Lands Acquisition Act and the Native Title Act, but that a conclusion based also on considerations drawn from legal authority, legal principle and legal policy should be preferred. Significantly, Justice Kirby found such a legal basis included the principle that native title in Australia is a special, distinctive and legally unique interest that is now given recognition by Australian common and statute law. Against that background of the history of previous non-recognition, the subsequent respect accorded to native title by this court and by the Federal Parliament, and the incontestable importance of native title to the cultural and economic advancement of Indigenous people in Australia, it is not unreasonable or legally unusual to expect that any deprivations and extinguishment of native title so hard won will not occur under legislation of any Australian legislature in the absence of provisions that are unambiguously clear and such as to demonstrate plainly that the law in question has been enacted by the lawmakers who have turned their particular attention to the type of deprivation and extinguishment that is propounded. And in a late footnote, just before coming into the lecture today, I saw that the full court had handed down their decision on the compensation decision made by Justice Mansfield in Griffiths, which is in fact precisely related to this case and to the compulsory acquisitions that occurred. And it was interesting that the full court dismissed almost all grounds of appeal. The only change they made to the determination was to reduce the percentage of compensation for non-exclusive native title from 80% of freehold to 65%, but they retained the solatium. So that is on its way to the High Court again, and I think for this particular group, that will be the fourth or fifth time they've been to the High Court. Similarly, in Northern Territory and Aboriginal and Arnhem Land Aboriginal Land Trust, which has been to the High Court a number of times in various guises, but in this particular matter that came before His Honour, the central issue was whether traditional Aboriginal owners had the right to exclude fishermen and others from tidal waters within the boundaries of a grant of fee simple under the Aboriginal Land Rights Northern Territory Act. Litigation arose because traditional owners to parts of Blue Mud Bay in northeast Arnhem Land wished to determine their rights to exclude others from the area. This proceeding was tried in the Federal Court concurrently with the native title claim, which included the tidal waters. The majority held that the Northern Territory Fisheries Act abrogated any public right to fish in Northern Territory tidal waters, and that the Fisheries Act did not confer the power to grant a licence under that Act, which would let the holder of it enter and fish in those tidal waters overlying Aboriginal land. So the result was that the traditional owners had exclusive access to their intertidal zones. Nearly 10 years later, negotiations are still going on with the Northern Territory Government over that decision. But Justice Kirby, agreeing with the majority, wrote in a separate judgment that this conclusion was consistent with his approach to the definition, enlargement or diminution of native title rights that he had sought to explain in Griffiths. That is, that native title cannot be extinguished except by express and unambiguous legislation. Justice Kirby's judicial writings revealed a vision of an underlying concept of native title that was holistic, an expression of communal responsibility and ownership, rather than a bundle of listed rights and activities susceptible to being chipped away piecemeal. It was a vision that considered native title to be construed to the benefit of Indigenous communities in light of Australia's history and principles of international law. He understood the canon provides rights to Indigenous peoples that are precarious and inherently fragile, but which cannot be abrogated except by clear and plain legislative intent. And this latter principle is a beam of light in the legal jungle. The reality of native title law in 2009, as developed by the High Court, was quite different. There was a high bar for continuity, which seemed to lack realism about how cultures change and adapt, particularly in circumstances experienced by Australia's Indigenous people with forced removal from land and other oppressive effects of colonialism. The characterisation of native title in a way that favoured specificity over generality, rather than the more holistic conception of native title, which would have left it less vulnerable to extinguishment, and an approach to the inconsistency test for extinguishment which all too readily had resulted in the extinguishment of native title. And for a time there was a lull in native title cases before the High Court. But in 2013, Akiba and the Commonwealth returned the attention of the High Court to the Torres Strait, the home of Mabo. Nearly 20 years after Mabo and its legislative response, the Torres Strait Islanders secured recognition of their right to take marine resources for commercial purposes as part of their non-exclusive native title rights in the sea. The extensive and comprehensive legislative controls on commercial fishing were held to regulate the rights rather than extinguishment. And Akiba was significant in the development of native title for three reasons. It recognised native title rights with a commercial character. There was a move away from over-specifying rights, and the fisheries legislation was found to regulate rather than extinguish. The holistic nature of the relationship between Indigenous groups in their land and their native title rights that was favoured by Justice Kirby is now in play in the High Court. The touchstone for differentiating extinguishment from coexistence, as the High Court has clearly said in a number of cases, is inconsistency. The turn to more moderation in extinguishment law in Akiba appears to be a more pronounced judicial reluctance to arrive at the conclusion of inconsistency with a preference for coexistence and for regulation over extinguishment. And this was very strongly the view of Justice Kirby in his dissenting judgments. Two other High Court cases followed swiftly after Akiba and continued this trend away from the harshment of extinguishment in the earlier cases. Both were also unanimous decisions. Carpeney and Dietman involved the successful use of a native title defence to a prosecution for possession of undersized abalone, with the state of South Australia arguing that the native title right to fish had been extinguished by the state's Fisheries Act. The High Court again found that the legislative regime was regulatory, not extinguishing. Not long after, in Western Australia and Brown, the High Court had the opportunity to clarify the law of extinguishment in the context of mineral leases granted in the Pilbara region in the 1960s. At the conclusion of mining, the land had been rehabilitated, apart from the open cut mine. This case gave the High Court the opportunity to address the extinguishing effect of a statutory grant conferring exclusive possession for a limited time. In another unanimous judgment, the Court favoured coexistence over extinguishment, reiterating the idea of necessity, stating inconsistency is that state of affairs where the existence of one right necessarily implies the non-existence of the other, and one right necessarily implies the non-existence of the other where there is a logical antinomy between them. That is, when a statement asserting the existence of one right cannot, without logical contradiction, stand at the same time as a statement asserting the existence of the other right. What Akiba tells us, confirmed by Carpeney and Brown, is that extinguishment of native title is now a legal conclusion of last resort. So Justice Kirby's dissenting views have now, in large part, found favour in the High Court in these three unanimous decisions, handed down some 10 years after the 2002 trilogy of cases in which His Honour recorded strong dissents. And finally, the picture of native title is moving closer to that envisioned through the eyes of Justice Kirby, and it is moving so fast that even after concluding these notes, just this evening, I read a decision, briefly, of Justice Raries, where he had revised a determination of native title from non-exclusive to exclusive, and his reason for so doing was because of the continued asserted right to speak for the country and to control access to it, which was one of the elements of exclusivity that Justice Kirby had put forward in the earlier cases. So thank you, Justice Kirby. It's been a delight revisiting all of these cases. I hope I have done you justice.
Thank you so much, Ms. Webb, for a most inspiring and stimulating lecture. The man himself, the Honorable Michael Kirby, needs no introduction, but I have to say this. I'm absolutely indebted to him because he made sure that he flew back yesterday into the country from his engagement at the UN in New York to be here so that he could be here with us this evening. It's my privilege to invite the Honorable Michael Kirby to move the vote of thanks.
Deputy Chancellor, Deputy Vice-Chancellor, Dean, Professor Bee-Chen Goh, my judicial colleague, the Honourable Margaret McMurdo, past President of the Court of Appeal of Queensland, Mrs Saffron, and other distinguished guests who are present. Thank you all very much for being here to hear what I think you'll agree was an absolutely brilliant and I found riveting story of the workings of my mind over a period of 13 years that I served on the High Court of Australia, virtually from the beginning until the end. The advent of the recognition in Mabo of native title coincided with a development that had occurred in the international dialogue of judges of common law countries. This is a sort of footnote to what you have just heard. In 1988 in Bangalore, India, a meeting was held chaired by Chief Justice Bhagwati of India, who died only a couple of weeks ago. And it brought together judges from common law countries, mainly Commonwealth countries, but there was one exception of Commonwealth judges, and that was a youngish woman judge from the DC Circuit in the United States of America by name Ruth Bader Ginsburg. And Ruth Ginsburg and I were the only judges present at the meeting in Bangalore who were not then members of the final Court of Appeal of the nation. And we took part in the Bangalore meeting in formulating the Bangalore Principles, which said that where there is no statute in the field and where the common law is ambiguous or is unclear, it is open to judges in common law countries to have regard to international human rights principles in clarifying or re-expressing the common law. This was a new principle, but we embraced it and it began to work its way in the manner of the common law in countries right around the world. And although it wasn't referred to, it was in the Mabo decision, I have no doubt that it was the then contemporaneous discussion of the Bangalore Principles and the beginning of courts under the High Court to apply them, including my good self in New South Wales in the Court of Appeal, that planted an idea into the very influential and important mind of F.G. Brennan, J., Justice Brennan of the High Court. And that idea was that although the common law had expressed the view that native title had been abolished by the act of sovereignty, the claim of sovereignty of the British in Australia, that notwithstanding that had lasted for 150 years, if it was inconsistent with international human rights law, what the judges had said before, the judges could unsay and say again in a way consistent with the universal principles of human rights. And so it was that in Mabo, at 175 Commonwealth Law Reports, page 1 at page 42, appears the passage in the reasons of Justice Brennan, which were embraced by the other judges, providing the key that unlocked the door that permitted the High Court to re-enter the field of native title and its recognition. And that was the assertion by Justice Brennan that the one principle of international law that is clear beyond doubt in civilised countries is that you cannot take away people's rights to property or otherwise except by very clear legislation and by decisions which are compatible with international human rights, and racially based decisions of deprivation are not consistent with the universal human rights. So, going on in my mind as I was working away in the very hard job in a court of appeal, much more cases and dealing with the cases day by day, was this stream of consciousness derived from the Bangalore principles. And if in any way decisions of mine, speeches of mine, and references to Ruth Bader Ginsburg and all the others who'd assembled in Bangalore played a part in the mind of Justice Brennan that led to the Mabo decision, then I would be very proud indeed, because that was a very, very bold decision, but a very principled one. And at about the time I arrived in the High Court, a young and vibrant barrister from the Northern Territory began to appear. She actually started in South Australia and went to the University of Adelaide to undertake a science degree. And it's a pity that there aren't more lawyers who do science degrees, because it makes you, first of all, very analytical, searching for empiricism and for very sound foundations, and questioning. Lionel Murphy did a science degree. Not many lawyers of the past do, and I hope more in the future will, because it makes them questioning of things that others might be more willing to accept. And Raelene Webb began to appear and to demonstrate her very considerable skills of detailed legal analysis. Now, for the young people who are here who are studying to be lawyers, there is no substitute for detail. There is no substitute for getting down into the engine room and looking at all the detail of the past authorities. And we've seen an absolute masterclass, if I can say so, tonight in the lecture named in my honour that has just been delivered. As I was taken on the journey tonight, I kept thinking of those intense, I won't say emotional, but sometimes fraught discussions with my colleagues in the High Court as we heard arguments, as we went out, as we discussed matters amongst ourselves, as at the end of the day we discussed matters very intensely, because we realised the importance of each and every one of the cases that you have just heard recounted. And I think also of walking to work along the lake, Burley Griffin, on my way to the High Court, thinking about the cases, thinking about how they all fitted together. You can get lost in that thorny wood and you can lose your way, and unless you can see the overall picture, you're just stumbling from one case to another. And so many was the day I would leave my partner Jan in our apartment in Canberra, walk to work, thinking about how one can get this issue into a conceptual framework. That was the problem for me, because working in the Law Reform Commission for 10 years and being exposed to very distinguished academic lawyers, it wasn't good enough when you got to the High Court to just patch up the particular case. You had to try to think deeply about the cases and to get the principles clear, and so that they could be applied. And so I thank our lecturer tonight. I think it was a wonderful lecture, and it will repay close scrutiny. And I'll be particularly looking at the recent cases in the High Court of Australia to see whether my contribution to their evolving thoughts has been duly acknowledged. I'm not holding my breath, but in the end, what does that matter? What matters is how we evolve an important principle of fundamental justice in Australia for the Aboriginal people of our land. It is true that I came on the longest journey that exists in the world across ocean. I came from New York, then to Los Angeles, and then across the Pacific, and up there in the clouds I looked with anticipation to this wonderful tribute that Southern Cross University has done to me by holding these lectures. I thank the Deputy Chancellor, I thank the Deputy Vice-Chancellor. I ask that my thanks be conveyed to the Council of the University for the fact that this has been continued, because tonight is an example of how valuable it is to analyse the way it happens. Now, the meeting in New York, and I'm nearly finished, was about Sustainable Development Goal number 3 of the new SDGs of the United Nations. These are the successors to the Millennium Development Goals, about which Kevin Rudd would speak endlessly, but they've now got the Sustainable Development Goals, and the Sustainable Development Goal number 3 is the right of access to people everywhere to essential medicines, that is to say medicines that save lives and that make lives tolerable for the people who are ill everywhere, everyone on our planet, and that this is to be attained by 2030. And one of the most important aspects of the issues that we discussed was the aspect of the disadvantage of Indigenous peoples, and not only in HIV, but also in malaria, in treatment of tuberculosis, and in diabetes, and in other conditions. Indigenous people do it hard. Indigenous people suffer great deprivations, not just in Australia. Indigenous people in Cambodia, Indigenous people in South America, they have and still suffer great disadvantages. And that's what makes the analysis that we've heard today in the High Court of Australia on title to land, and therefore on access to money, access to the money with which Indigenous people can correct the injustices and attain equality of citizenship, why it's so important, and why I thought it was always very important. And I'm very grateful to Raylene for analysing the cases and revealing the common threads, and revealing the occasional light that I was able to throw, and that the other justices endeavoured to throw on the problem which we've examined tonight. So for a wonderful lecture, in the context of the search of our species for universal human rights, and in the particular context of the disadvantages Indigenous people have suffered throughout the world, and especially in our own country, I think we all owe a tremendous round of applause. Let it be, as they used to say in the Soviet Union when Stalin made a really wonderful speech, thunderous prolonged applause. But happily, Raylene, you're no Stalin. You are a visionary and a practical lawyer and a person of principle. And I think we've been given a great treat by the analysis that we received tonight. Thank you.